My brothers and sisters, pro-life leader Frank Pavone here, director of Priests for Life and Pro-Life Vote. Our election efforts this year, not only to elect pro-life candidates, but to defeat pro-abortion ballot measures that are in place and on the ballot in 10 states. We've been talking to you in this special series about these ballot measures with the help of some legal experts and some medical experts. And today I want to give you an overview of these ballot measures from another perspective. That is, that these measures, first of all, go far beyond anything that Roe v. Wade ever imposed on us and all the other rulings of the Supreme Court on abortion over the course of 50 years. And that secondly, what is happening here is an absolutely unwarranted, irrational dismissal of 50 years of deliberation, negotiation, painful wrestling back and forth between the federal level, the state level, within the states, in the courts, in the legislatures, in public opinion, laws being passed, laws being struck down, laws being amended, the Supreme Court ruling, the Supreme Court reversing its rulings. We have had 50 years of intensive battles over abortion. And in the course of that time, certain consensus points have emerged among the American people. What these ballot measures do, brothers and sisters, is in one fell swoop, in one day, by one election, overturn and close the door and throw away the key on so many consensus points that have been hammered out so diligently over these years. And they throw away the key and cement abortion policy in the most extreme position possible. Now, just think about this for a moment. There's a reason why over 50 years there have been hundreds of court decisions on abortion, and that the Supreme Court itself has ruled not once, not twice, not three times, but dozens of times on abortion. There's a reason why state legislatures across the nation, even under Roe v. Wade, have passed very significant measures that put into law the consensus of the American people on various points. We're going to go through some of this and thereby show you how unreasonable it is just to wipe all that away in a single day with these ballot measures. Let's get into it so you understand more clearly what it is that I'm talking about. I'm going to quote for you the wording of some of these ballot measures, looking at this from the point of view of how do these measures talk about the so-called right to abortion. Now, I'm going to use our handy little tablet here, so let's transfer over to that. And let me put, first of all, a phrase here that we're going to see come up in a number of these amendments. Fundamental right to abortion. Now, not all of these amendments use this exact wording, but they all end up in that basic same place. And what I want to point out right away is that this has not been the position of the courts on abortion over these last 50 years. It has not been this. Abortion has been acknowledged as some kind of a right, but not consistently acknowledged as a fundamental right. And what is the significance of that? The significance of that, and we can come back to full screen here, is that when you have a fundamental right, there's a specific meaning to that that lawyers and courts and legislators understand, that limits what the government can do to restrict that right. You have a fundamental right to freedom of speech. Are there some ways in which the government can restrict it? Well, yes, but they're very, 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 very small. There's only a very little bit of wiggle room that the government has to limit what is a fundamental right. You have a fundamental right to religious freedom. I had to defend my fundamental right to religious freedom all the way up to the U.S. Supreme Court when the Obama Biden administration tried to interfere with it. So it was very clear that the government can only do that in very, very limited ways. When, in other words, a law is passed and then that law is challenged. So let's say a pro-life law is passed restricting abortion in some way, right? And the abortion industry doesn't like that because it takes away business from them. So they go into court and they say, no, that law cannot stand. That law is unconstitutional. How does the court decide whether to strike down that law and say this can no longer be enforced, or on the other hand, to uphold that law and say there's no constitutional problem with this law? The court has various standards of review. So what I'm going to do here is let us go back to the whiteboard. When you call something a fundamental right, you are using the highest standard of review called strict scrutiny. What that means is when a law is passed, for the government to uphold it, the government has to show that it has a compelling interest. In other words, the government is trying to accomplish something that is so important. It's called compelling, of the highest level, compelling interest, and that it is, if it's restricting your right, it's using the least restrictive means to advance its compelling interest, the least restrictive means. I'm putting these words up here because lawyers and courts and every judge in America is familiar with these terms. They have been used for a very long time. You see them popping up in judicial decisions all over the place and in laws. And the understanding of these things is clear. This is the highest bar. You can't have a law that limits a fundamental right unless the government can show it's advancing a compelling interest using the least restrictive means. Why are you limiting my freedom of religion in this particular regard? Well, because we have a very good reason, and we just have to restrict your right here. It's the least restrictive way that we could do that. So let me explain to you how, when my religious freedom was being violated and that of my ministry, Priests for Life, the Obama-Biden administration was telling us that we had to provide coverage in our health insurance plans for our employees for certain kinds of abortion. And we said, no, there's no way we're going to do that. And the government said, well, we have a compelling interest to make sure that women have access to these things. And what we were able to show was that, look, you don't have to restrict our right not to be involved in this in order to advance your compelling interest. Because if they want to obtain contraceptives, even those that cause early abortions, there's plenty of ways in our society that they can do that without our help. They were also exempting large corporations from having to do this while forcing smaller corporations like ours who had religious objections to do it, to have to do it. And we said, well, why don't you have those larger businesses that don't have any objection to this at all provide this for people and stop our smaller groups from having to do something that we gravely object to. Long story short, we won in that particular argument. But the bottom line is that the principle here was on display, that the government can't restrict a fundamental right that you have, like the freedom of religion or like freedom of speech, unless it has, again, and these are widely known terms in the legal community, a compelling interest and is advancing it by the least restrictive means. Now, let's go back to the whiteboard, because there are other levels of scrutiny There's what's called intermediate scrutiny. And what that means is if the government is going to pass a law and it's going to be deemed constitutional, this second level down, intermediate scrutiny, means that the law has to be related substantially to an important government interest. Now, these things, where you draw these lines, of course, is exactly the argumentation that's going to go on in the court. But there is a distinction. It's less strict than strict scrutiny. It's an important interest of the government, and they have to show that the law is substantially related to it. Okay. So things that have been challenged under this have to do, for example, with if you have a law that treats men and women differently, there's got to be an important interest to justify doing that. Okay. Intermediate scrutiny. Now, let me go to a new screen here and give you the third level, which is called rational basis. The state passes a law. Again, it might be regulating, restricting abortion in some fashion. And this is the easiest bar to pass for a state to claim, yeah, our law is perfectly constitutional. There's no reason for the court to strike it down. And the explanation of this is that that particular law has a reasonable relationship. In other words, any reasonable person would say that it's connected to what? To a legitimate state interest. Now, you notice how the language is kind of broader, a kind of softer, right? It's not a compelling state interest. It's not even what's called an important government interest. It's a legitimate state interest. In other words, to simplify all this, it makes sense for the state to do it. It makes sense to the ordinary person. If a law is regarded under this rubric of rational basis, if it makes sense to something that the state is legitimately supposed to do, then there's no reason to strike it down in the courts. Let me give you an example. Seatbelt laws, okay? What's the interest of the state? Well, to keep people safe while they're driving, right? And is a seatbelt somehow related to that? Does it make sense that that could advance safety? Of course it does. All right. Here's the bottom line, brothers and sisters. The Dobbs decision, which was the most recent decision of the Supreme Court on abortion, it was the 2022 decision that, actually, it wasn't the very most recent on abortion, but it was the one that reversed Roe versus Wade 2 years ago. What the Dobbs decision did, and this can be understood as the most basic and important impact of that decision, was that it took laws that restrict or regulate abortion, and it said that from now on, the courts will review these laws on the rational basis standard. In other words, if the law makes sense in connection to something the state is supposed to be doing, well, then the courts should bow to the legislatures, the will of the people expressed through their elected representatives. And the court should say, listen, there's no constitutional reason to strike down this law if the lawmakers of that state, or of the federal Congress for that matter, didn't take away their right to set abortion policy, decide that there should be, for example, limits on taxpayer funding of abortion, or the requirement that a parent give consent before a minor has an abortion, or the requirement that the person getting the abortion should be given certain information about the procedure, about the baby, about the risks, about the alternatives. Maybe should be required to see the ultrasound of the baby and then be given a day or maybe 2 days or maybe 3 days to consider her choice, consider her decision. These are all examples of the kinds of laws that have been passed over the last 50 years. The Dobbs decision said, if a legislature decides that that's what they want to do, and they're doing it obviously for the the well-being of that woman, that she would have an informed choice, that we would protect her safety, that there would be clinic regulations, that, for example, an abortion facility would have to make sure that the abortionist has hospital administered privileges in a nearby hospital, that all of these things are reasonable. It's not that everybody's going to agree with them, but if the legislature passes them, they're reasonably related to a legitimate interest of the state. There's no constitutional problem with that. So what this did, in other words, was it opened the door very wide to states passing laws that most Americans agree with. Let me read for you from the Dobbs decision on this point. A law regulating abortion, like other health and welfare laws, is entitled to a strong presumption of validity. It must be sustained if there is a rational basis. Remember, I told you, these words are known, these phrases are used. A rational basis on which the legislature could have thought that it would serve, here's another phrase again that's widely known, legitimate state interests. And then it goes on to give some examples. These legitimate interests include respect for and preservation of prenatal life at all stages of development, the protection of maternal health and safety, the elimination of particularly gruesome or barbaric medical procedures, the preservation of the integrity of the medical profession, the mitigation of fetal pain, and the prevention of discrimination on the basis of race, sex, or disability. Now, all of those legitimate state interests have been the goal of various types of pro-life laws that have been passed in various states at various times, even laws passed by the United States Congress. The Congress passed, for example, a ban on partial birth abortion, a particular procedure by which the child is partially delivered, is hanging out of the mother's body, all except his head, and then is stuck in the back of the neck with scissors, and the brains are sucked out, and the baby thereby is killed. That procedure is so barbaric that the Congress passed and the Supreme Court upheld the law saying this will not be prohibited. This will not be permitted, rather. This will be prohibited by federal law. That law was passed in 2003 and upheld by the court 4 years later. Well, brothers and sisters, one of the legitimate interests was protecting babies from pain. Another legitimate interest was protecting the medical profession from being seen as a profession of barbarity. We have to preserve some respect for the medical profession. It's so important for the lives and health of all of us. I have here a summary of Supreme Court decisions over the years, and I want to point out, because you'll see these legitimate state interests being debated and going back and forth. I want to point out a few of these, and notice what I'm saying about this and where I'm going with this. These state ballot measures, each in their own way and using slightly different language, wipe all this away. And they change the standard from the rational basis standard. Is it reasonably advancing a legitimate state interest? Are you trying to keep the medical profession from looking like a bunch of barbarians? Are you trying to promote the health and safety of women by having some clinic safety regulations or some requirements of what the qualifications the abortionist has to have? Are you advancing a legitimate state interest in a reasonable way? These amendments, even though the Dobbs decision, the Supreme Court just finished saying that abortion policy should be regulated on this rational basis standard, in other words, let the legislatures do what they think is best, it pumps abortion way back up again to the highest standard of strict scrutiny, putting it on the level of freedom of religion, putting it on the level of freedom of speech, putting it in an arena where the government can't limit that right unless it can show it has a compelling interest and is doing it in the least restrictive way. In other words, your right to abortion is unfettered. It's not going to be in any way hindered or even delayed, abortion is, in other words, a fundamental right. Now, I'm going to look with you at the language of some of these amendments in just a moment to show you that this is exactly what they're aiming to accomplish, because they're using the long-held, recognized language that most voters are not going to recognize because they're not attorneys. They haven't read dozens and dozens of court decisions on abortion or other constitutional matters. They don't know where this is heading. They don't know the hidden meaning. And it's not that it's hidden. It's just that you have to know the history here. Let me show you how over 50 years the Supreme Court has wrestled with this. The other federal courts have wrestled with it. All the state legislatures have wrestled with it. And in wrestling with these questions, there has emerged a certain consensus among the American people. Let's take a look. So Roe v. Wade and Doe v. Bolton in 1973 said abortion, it's a right under the Constitution. Okay. But then, that was in 1973. Right away, 2 years later, another Supreme Court case on abortion. Can clinics advertise for it? Well, yes. Well, what if a state says that a non-physician cannot perform an abortion? Is that constitutional? And the court said yes. The state can permit those who are not physicians to do abortions, but if it has a prohibition on that, that's okay too. Okay, so we started wrestling with that. The very next year, more laws in regarding parental consent were considered by the court. The next year after that, 1977, the Supreme Court said states do not have to fund abortions. They have to permit them to a certain extent, but they don't have to fund them. So the funding issue came up. Also in 1977, the court said if a state wants to prohibit the performance of abortion in public hospitals, that's okay, that's constitutional. How about the state pursuing an interest in the life of the unborn child after viability? In other words, the state says, wait a minute, the right to abortion shouldn't be absolute, especially after the baby can survive outside the womb. We have to look for ways maybe to protect that baby. The court in 1979 said, yeah, that's okay. And remember, it's not the court coming up with these ideas and just imposing them on the public. The court is considering these things only because they started out with a consensus among the people who elected lawmakers, lobbied them, they had debated these laws, they passed these laws, then the laws were challenged by the other side, and they were challenged at the first level, the district court, and then they may have been challenged in the state courts as well, then they were challenged in the appellate courts, then they were taken up by the Supreme Court. So every one of these decisions means a lot of things were percolating underneath, and maybe there were conflicting decisions from different parts of the country. People were debating it, and people were giving their experience and talking about how this law impacted them negatively or positively. That's how all these cases came about. In 1980, big decision called Harris v. McRae restricted federal funding of abortion. It upheld the so-called Hyde Amendment. Now, here's a measure passed by the Congress. So the input of people from across the country, agreement of legislators from across the country. And the court said, yeah, you can restrict federal funding of abortion. And it recognized that abortion was different from other medical procedures because it said no other procedure involves the purposeful termination of a potential life. 1981, the court said it's okay if a state requires an abortionist to notify one of the minor girl's parents before performing an abortion. Parental notification. The court then, wrestling with this, in 1983, struck down some laws having to do with informed consent or 24-hour waiting periods or the requirement that later abortions be performed in hospitals or that one parent has to consent or even how fetal remains were to be disposed of. Now, that decision would later be overturned by the court. We're going to see that in a moment. 1983, a Missouri law was upheld requiring that abortions done after viability be attended by a second physician and that a pathology report be filed for each abortion. Also in 1983, The Supreme Court affirmed the conviction of an abortionist who did a second trimester abortion in a facility that wasn't properly licensed. So they were reinforcing licensing requirements. 1986, the Supreme Court struck down some laws in Pennsylvania, again, having to do with informed consent, reporting of abortion statistics, and some other requirements as well, that the abortionist, for example, use the method of abortion most likely to preserve the life of a viable child. And then again, the question of a second physician, the court said no to these laws. But then in 1989, the Webster decision out of Missouri gave more leeway by saying, yes, the state can prohibit the use of public facilities for abortions and can require the abortionist to determine the viability of a child after 20 weeks. Then in 1990, there was a Supreme Court decision allowing a 48-hour waiting period for minors following parental notification. 1991, the Supreme Court, Rust v. Sullivan was the case, upheld the federal regulation under Title X to prohibit those funds from going to abortion. Then a big decision in 1992, Planned Parenthood versus Casey, the court reversed itself on some of these matters about informed consent, for example. There could be informed consent requirements where before someone gets an abortion, the state has to give her certain information about the procedure, its risks, its alternatives, about the baby, the development of the baby, and then let her consider that information. And then if she still wants to go forward, she goes forward, but mandatory 24-hour waiting period to consider that information. The collection of abortion statistics. The court said, wait a minute, we said a few years ago that this was unconstitutional, but we were wrong. This is constitutional. You can allow those limits. What I'm pointing out to you is, again, 50 years of nationwide deliberation about this in legislatures and at all the different levels of the courts, all the way up to the Supreme Court. And not even the Supreme Court was completely sure of itself, went back and forth on some of these things. 1997, a law was upheld that said only licensed physicians can perform abortions. In 2007, I made reference to this before, the Supreme Court said it is okay for the states and even the Congress to prohibit the particular method of abortion called partial birth abortion. Now, in all these decisions, the court is rejecting the idea that abortion is a fundamental right. Let me make that clear. Roe versus Wade said the right to abortion is not absolute. The state has other interests it can pursue, including interests in the life of that developing baby, and including interests in preserving the health and safety of the mother, and in preserving other things, the legitimate state interests that are part of that rational basis standard of review that we talked about already. Here's the question with these abortion amendments, are we really ready to say, you know what? Dozens of Supreme Court decisions, hundreds of court decisions on the lower levels, and hundreds more of state laws, each one of which was carefully deliberated, and there were hearings, and there were debates, and there were votes, and there were amendments. And people had input by the hundreds of thousands across the country for 50 years. I ask you today, are we ready to say that all of that was a waste of time? All those debates were a waste of oxygen. All those decisions were a waste of paper. And just in one fell swoop, we're going to pretend to solve this issue by saying, you know what? That's it. No more debate. No more restrictions on abortion. No more back and forth about the funding of abortion. No more arguments about how the parents should be involved in abortion. No more of this. Abortion's a fundamental right. You can't interfere with it. You got to pay for it. You can't start passing clinic regulations. You can't have parental consent laws. You can't have informed consent laws. You can't have requirements that are going to put all kinds of health and safety restrictions on these clinics. It's a fundamental right. Don't get in our way. If we want to have an abortion, the abortion is saying, don't get in our way. If we want to perform an abortion, government, get off our backs. But brothers and sisters, the problem with that is you've got 50 years of history here. And this wasn't stuff that came down from on high. This was stuff that came up from below. This wasn't stuff that was imposed by government. These were things that were agreed on by the people. Most states have parental involvement laws, even right now. Most states, most Americans agree that they shouldn't be forced to pay for abortion. Most of people understand that there need to be health and safety regulations on the clinics. And yet, these initiatives say things like, for example, Arizona Prop 139, every individual has a fundamental right to abortion. Nebraska, all persons shall have a fundamental right to abortion. Nevada, question 6, all individuals shall have a fundamental right to abortion. Colorado, Amendment 79, the right to abortion is hereby recognized. Then the Montana CI 128, there is a right to make and carry out decisions about one's pregnancy, including the right to abortion. And these amendments and the others like them are putting that right in that category of strict scrutiny. How do I know that? What did I tell you? The common language in the courts is that you can't limit a fundamental right unless there's a compelling government interest being advanced by the least restrictive means. Well, guess what? The language, for example, Arizona Prop 139, can't deny, restrict, or interfere with the right to abortion unless justified by a compelling state interest that is achieved by the least restrictive means. Oh, that sounds familiar. You think they just came up with that out of thin air? Of course not. They're speaking within this context that they know full well of abortion litigation. Nevada, question 6. Oh, look, there again we see that this right cannot be denied, burdened, or infringed upon unless justified by a compelling state interest that is achieved by the least restrictive means. Well, look once again at the Montana initiative. The right to abortion shall not be denied or burdened unless justified by what? A compelling government interest achieved by the least restrictive means. You see what I'm saying here? These things mean something. And you think the average voter reading this on the ballot, the very one day of voting, and they're reading this for the first time, that they're going to understand that this means that none of those reasonable consensus points that have been hammered out throughout the country and up and down the legislative and court system of our nation for 5 decades and agreed upon by most of the American people, that these are all going to be wiped away in one day, and the door closed, locked, and the key thrown away to keep the people from changing that ever again. You think they're going to understand that? These are dangerous amendments, brothers and sisters. They go way too far because they're throwing away the legitimate debate of the American people and saying, shut up, keep quiet, accept this fundamental right, and don't try to change it at all in the future. That isn't going to work. The people, as they come to know what is going on here, are simply not going to accept that. Brothers and sisters, we're going to continue this discussion next time, but I wanted to bring this into perspective for you. Please go back, review what I've said to you here, look at the quotations and the details here, and look at our website, State Ballot Measures. Friends, thank you for watching. Please share these videos, spread around these programs, and we'll continue between now and November 5th to bring you more detailed information about these ballot measures. If you are watching these programs carefully, taking notes and reviewing the material, you know more about these amendments than anybody else in the country. You are doing exactly what you need to do to be an informed voter. Please be vigilant in bringing this information to as many other voters as you can before they vote yes on any of these amendments. God bless you, my friends. Talk to you soon.
Hello, I'm Dr. Alveda King, board member of Priest for Life. More money is being spent in America to kill babies in the womb than to save them. Together, we need to change that, and today I want to invite you to support our work at Priest for Life. Why ours rather than other groups? Because we have a unique team that helps lead in every arena of the fight against abortion, and we activate the churches where you find people who are most likely to get involved in that fight. To awaken a pastor about abortion is to awaken thousands of people he serves. We do not receive church funding or government grants. We rely on you for individual donations. We have a very high evaluation among charities and top security on our donation site, prolifegift.org. You can go there for a one-time gift or to become a monthly donor, or you can call us at 321-500-1000.